Good morning. How are you?
Okay.
Good. I like hearing that.
I said, Bob, I'm floating.
Well, all right. So we're here today on a plea setting. Is that right? Or is this just a status setting?
No, we're actually for a motion to substitute.
All right. And is our attorney going to be present? Do we know?
She is not. I have an email from her. Hopefully that works, and I apologize, I did not print it out. I'm happy to print it out or email it to you if you prefer, but basically Sloan is she was hospitalized. She's out of the hospital now, but it's still going to be a few weeks before she's able to return back to work.
Okay.
And so she is in agreement with us substituting in on it. But then obviously we would need some time to work the case.
Well, and that's the issue is like the timing in this whole thing. And I have here that in March 2024, we were going to start undergoing the mental health court evaluation and assessment to be entered into that.
And we did begin that. There was an initial assessment. There were some areas of concern that were identified specifically with housing. It took a fairly substantial amount of time for us to get a housing arrangement that the state was comfortable with moving forward. Because the proposal initially from mental health court was just to put her in a hotel without any type of supervision or oversight. The state was uncomfortable with that. Since then, we've been able to find her housing and a placement. So
when did the housing situation arise?
back in
When I got evicted originally,
When was that?
back in June of last year, whenever I lost my property off of 400 Boulder Bluff, and then I moved on to 1100 in an RV. Then I moved from 1100 Alpine. Then I moved from 1100 Alpine to 1001 Oak Meadows. Then I had a fire in my RV, which just one of those
When was
purple
that?
ACs. That was in July of this year, and then I was living in a tent on the exact same property because I had my dogs, and now I have a residence that I am currently moving into, but somebody kicked my door in this over the weekend, which the sheriff's department did have started a case on it. But I am currently moving into it, but I have to get paperwork signed and notarized, but during the fire, all my stuff got burned.
Right.
So I have no ID or anything like that except for my mugshots. And so I need a notary public to notarize, and the landlord knows it. And I have all this trail in emails and everything, and I can send it to them and they can whatever. But and I was also in the hospital for MRSA.
So here's my concern. I am empathetic to all of these things. We know, I mean, this case was indicted in May of 2023. It's what, 15 months old. And if we have someone who needs to go into the program that's being proposed, I don't think this came on in the last few months. It's something that should have happened a long time ago. And here we are now, 15 months later. And so what I'm trying to understand is if either of y'all know why if this would have been done timely, the July 2024 fire, it would have happened we would have had her in the program that we want her in a long time before. And let's be honest, if that program is going on, and I think it does great things, potentially we'd never have the fire because everything is working out and we're helping this person. And so what concerns me is that our dilatory work on this case is partly puts it on us, not on the defendant. And you've had to wait this long for us to get it sorted out. And if the program's going to be successful, we need to do things timely. So does anyone know why it took so long for us to get started with the assessment and getting her into the program?
Judge, part of it is in order to do the initial assessment and begin the process, she has to have an attorney. I'm not sure exactly when she was appointed an attorney.
I can tell you. She was appointed an attorney
I went to Shy before I was told to.
on May the 16th, 2023.
I do know that the felony mental health court program is relatively new, and I think that might have been part of the issue here. Obviously not the whole issue.
Right.
but,
Right. So what I want to be clear is I'm for the program. I'm for, you know, you guys need to be in on these cases from the beginning. I'm for that. I just think that if, you know, the program's not being successful, if we're not timely responding to the issue.
Mhm.
Because if it's important enough to go into this court, it's important enough to us, for us to do it timely. And that's, I'm just trying to figure that out. And, you know, I'm having a hard time getting some answers to it.
This case predated the felony mental health court. And so there was some, based on the notes, there was some, we were aware that there were some serious mental health issues involved in this case, and there was a desire to have her evaluated, but initially we did not have that felony mental health court. Once we were able to get the felony mental health court started, she started kind of the evaluation process, but being one of the first people to go through, and with the housing issues causing a delay, that's my understanding of what we've been working through.
Okay. So what is our sitting here?
Status.
Okay,
For
status.
you to go to the-
I'm sorry.
There might be a little confusion in the case right now. There's a plea setting in misdemeanor mental health court, not felony mental health court, set by the mental health court coordinator for the 16th on 2 p.m.
When is our next setting?
Is the 16th, is that on or leading to?
Okay. She's the 16th of this month.
Yes.
Okay. What, you look like you're surprised by
I
this.
am, because I don't know, so I have to, I'm in both courts on the 16th, and I'm not.
Does she
aware
have
of
a
anything
misdemeanor
like that.
case?
I'm
No.
not aware.
Not that I'm
No.
aware of, Your Honor.
This is the only case that I have, so I don't know what the hell's going on.
Right.
Mental health court set her in their court in front of Judge Brown on the 16th at 2 p.m.
Okay.
I don't know,
That's how they do it, Judge. I don't need to, I mean, they're all done through Judge Brown's court, at least as of now for the mental health court meetings.
I mean, do they set defendants while they're still pending in a felony court?
No, my understanding is for the felony mental health court that they are transferred to the 453rd, and then a plea goes through in Judge Tibby's court that requires participation in the mental health court as a condition of that plea.
Right, I think it's just to streamline it. I believe that the coordinator, as she usually does, set it on the 16th, the same day as the felony,
Oh,
assuming that in one fell swoop.
I appreciate that.
All levels. Sorry to interrupt.
Yeah, no, I mean, understanding that they set them for the same time. So here's my concern is that we're now at the kind of end of the line, and Miss Underwood should know this case and should be ready for trial, which is coming up shortly. And I don't know, I mean, if it's taken 15 months, what is going to make me think that in the next 2 months, it's going to be resolved before we're set for trial? And, you know, we're going to, on this case, which shouldn't take this long, we're going to be at 18 months.
There was a plea offer that was made and requiring mental health court as a condition that was made in July. But I believe that's when Ms. Sloan started having a lot of her health issues. And so my understanding is she has not been able to convey that offer to the defendant and discuss with her the strengths, weaknesses of the case and what all that offer would entail. So
Okay,
Basically, everything got put on hold at that point.
so, do you understand what we're here today is because, your attorney, who you've been with for a while,
Right, she got
Um,
sick.
is right, and so, the attorney to your right wants to come in and take over the case.
Yes.
And I have confidence in them on that. The only issue is we're not going to change in the middle and cause further delay to
You don't
this
want to change
case.
horses in the middle of the ride.
That's right. Well said. To move forward, so we're looking at, if we have the 16th, it could potentially be a October 16th trial date. And so will you all be able to go to trial at that time?
So we have not reviewed the discovery yet. I have no idea how in-depth it is, but I can tell you we have 8 attorneys that we can work on it and do our best to be ready.
Okay, I mean, it's already on a case like this, it's a state jail felony and we have someone who I'm being told that needs this special attention. And I'm fine with that. And I want you to get that. Then why haven't we done it? Right? And I know it's not on you. And
Because I've been trying to do everything that everybody's asked. Everything.
And Judge, we
right,
have
so then
shared,
that's, you know what, and I appreciate that. That means that there's something in the system that's not working. Because if you need this help, then we should be able to timely deliver it.
we have shared discovery with the PD's office as of Friday. Just an abundance of caution, understanding that they have filed to come onto the case. So it has been shared.
Okay. All right. Well, you understand the timeline. You understand that the change cannot be used as a reason to put off trial.
So I understand the court's concern. And I can guarantee that we will do everything that we possibly can to be ready on the court's timeline. But with the understanding of, we haven't looked at the discovery yet. And so if once we get in there and we see that there's an issue or whatever, then at that time I may need to file a continuance.
Okay.
But it
Why don't
would,
we do this? Since you have the discovery, why don't we give you some time to take a look at the volume? And then we'll come back and discuss it.
okay, well, and it would be any issues as well. I mean, my understanding is that Ms. Williams wants to go into mental health court. We also agree that mental health court is usually a good thing. We just want to make sure, go through discovery with her, make sure in this particular case that that's the best option for her. But, yes, I mean, we would need to be able to do that together with her and,
Well, let me give you some time to go take a look and see kind of what things look like. I don't know if you have access where you can see here in court, or do you need to go back to the office?
well, I mean, I did see there was like 700 pictures or something, if I'm remembering the right case, but obviously pictures are fast to go through.
Right.
I just don't know. I mean, she has not reviewed discovery. And so that's something that needs.
You've never seen
I've
discovery?
never seen any of it. I've
So-
never seen any of it. I know that and I know publicly that there was a news, 2 separate news things, and I didn't really want to see those because I didn't.
Okay, stop.
Yeah.
I just don't want to get
No,
into the
no,
facts
we're
right
okay,
now,
we're
okay?
okay.
That's right.
It appears from looking at evidence.com that there's 3 videos that I'm going to assume are probably body cams and or an interview with the defendant. The bulk of the discovery appears to be over almost 800 photographs. And then there's 5 documents of reports, arrest affidavits and such. So it's primarily photographs.
Okay, so I mean, volume wise, that sounds very manageable. Obviously, we need to review the discovery with her
That's fair.
and look at if there's potential legal issues.
Okay, I've signed the substitution, so they will be your attorneys, and make sure that you continue to reach out and give them the information that they need, and hopefully we can get things moving forward.
Yes, sir.
All right, thank you.
Thank you. This email that I have from Miss Underwood, do you want me to forward that to the court so it can be? in
No, I
the
take
file?
your word for it.
Thank you, sir.
Yes, ma'am, thank you.
And did you need an order? You
I already have it and I've signed it.
Thank
It's in
you.
the file.
Very good.
Yep.
Thank you, Your Honor.
And we're keeping the 916 plea setting?
Yes.
Okay.
They would be excused, Your Honor.
Yes, thank y'all for being here. Do we need to get Mr. McGilvery up for you?
Yes, Your Honor.
Okay,
I'm here on that.
okay, thank you for being here. Morning. Who do we have you on? Flores is here.
Yes.
Come on up, Ms. Flores. All right, we're here on this case to check out the status of the CPS records, is that right?
Yes, sir.
What's the status date?
We have gotten those in, Judge.
Great.
Have been made available for defense counsel to review. We
Great.
also have the forensic interview. It has been downloaded or uploaded, whatever the case may be, to evidence.com. So it looks like we have all of the discovery needed in the case. We've also made contact with the complainant and made an offer to defense counsel.
All right, anything to add to that?
Nothing, Judge. We just need a little bit of time to review the CPS records, but that all seems correct.
Okay, well, good deal. Looking at the timing of this case, then we had set off in July. We had said that our next setting would be a police setting, I think. And we put that off so that we could get these things handled. So now we will move to a plea setting. That does not mean, sir, that you have to plea at the next setting, but if there's not a resolution, the setting after that would be a trial setting. Does that make sense? Just to give you kind of a timeline of what we're looking at, you understand what's happening in your case. Make sense? But I'm in no way saying that the next setting, that means you have to plea. That's not what that setting means. It's just kind of a, that's the name they've given to it. Okay, all right. Thank you very much.
Thank you, Judge.
Yep, we'll see you after you get your reset. We'll see you at the next. Boris, do we need to bring your client up? Or are you still conferring?
I was actually in the process of negotiating a plea, and
Okay,
in the interest of time, I'm probably going to make a request to just reset to the trial docket or plea docket.
Okay. I mean,
he's here.
he's in jail, so if it's something that we think we can work out,
I'm trying.
Yeah.
I think I can work it out.
well, if you don't mind sticking around, I'll let you talk
I'd be
to.
happy to, Judge.
Okay, thank you.
Is he on the way up? No. Okay, your guy is. My guy is? Yeah. I don't know. Okay. If I could control him downstairs in private.
Yeah, no problem.
So I hate to jumbling up the down. You talked to him. Yeah, but I just got another update. I can talk to him a little bit more about that. Please.
Mr. Evans, you just when you come back, just let us know that you're ready and, because we may be done, but we're not going anywhere. Thank you, sir. Thank you all for being here.
Absolutely. Thank you, Judge.
Morning, how are you?
Hey, Judge, good morning.
Good. Thank you. Good morning.
Morning.
Did you have a good weekend?
Yeah.
Good, that's good. It was pleasant out this weekend.
This morning.
Yeah. It felt a little bit like fall. I mean, Texas fall.
Yeah.
It was still hot, but it's nice.
This is a small document. This is a small document.
Yeah, go ahead. Yeah, go ahead. If you want to step out, I think that's fine. Okay, I mean, we just have 2 custody cases. I'm step out then. State and defense, if y'all get some resolution or whenever you're ready for me to come back in and tell the status, let's get him up and tell him what the status is.
Oh, absolutely.
Yes, sir.
And we'll move forward. Thank you.
Thank you.
False alarm. Yeah.
Talk about what? I'm not gonna point out that you just shut it off.
Sorry.
Monday.
And that stuff is emergency jail for 2 days. And then whichever, again, I'm just gonna pick one, and then we'll cross out the other one. So. Yes. Right up there.
Your Honor, I'm gonna step down and confer with him.
Okay.
He's in custody before we do the up and down.
Whenever you're ready, let me know.
My hope is that this is a pill he can swallow.
Okay, very good.
Do that shortly.
Thank you, sir. We're done.
Thank you, sir.
You're welcome. All right, let me know when y'all are ready. Do we have, are either one of these going to go the direction of probation?
No, they're both time offers.
Okay, so I don't know that you have to stick around.
Thank
You're welcome to, but I know you guys are busy.
Thanks, sir.
Yep.
Becky, what date do we give Francisco Flores?
October 15th.
You can. Are you ready, Mr. Evans? Almost. Okay. Let me know. So this is. Yeah. Okay. We'll go grab it. Yeah. Oh, no, that's not. Would you like Mr. McGill read it? Yeah. Yeah, you're good. Just judge a period that you read. Oh.
Is there a specific issue or anything to work on, or is it just a impasse?
He's got one question, it's one of the real good ones. Some suspicion.
The original deferred. Yeah. You can either ask to withdraw and they'll handle everything together, or you can ask the judge to do it and then they'll sort of prosecute them. Engagement. The goal is not to put your guy at a worse position than Sean, though. Like,
Would make sense. We're gonna have the defendant up here. Who's running it? Where are you? Looks like I'm gonna have to leave. Oh, okay. Then we need to pay more. I need to go back. I prefer to go back downstairs too. Absolutely. Let me just tell them. Yeah. So you know where you come out. Okay.
If it's easier, I don't mind stepping out so you can go over the paperwork.
Or you can go in here. Whatever we do. Okay.
There's 2 counts, we're just doing 1. I'll do that up there.
All right. You want me to look up the dates?
Sorry?
You want me to look up the dates?
For the,
Yeah. Can't be too hard to figure out.
no, it's gonna require some addition, so. I'll stick my head in and let you know what it is as soon as I calculate it.
I'm going If you have any questions, stop.
It's 97 days.
Okay, thank you. Time, keep it. All right, so the defendant, and me, this is with the consideration. We're going to plead to one count of robbery. They're going to waive the other count of robbery, meaning 10 minutes only. The reason there were two counts was because Sean pepper sprayed two of the associates. Each can name each state is going to dismiss the other case with the engagement with the organized criminal charge associated. We're going to decline the assault charge and engagement with organized criminal charges associated with that. That means they're not going to do it. They're not going to turn around and indict you for that case. As long as the judge approves this plea, I'll do yes. I've got, hold on, are these cameras recording? Okay, we need to take it out. I don't know. I need to take it out. I don't know. I'm sorry, sir. This just, it says that live streaming everything on YouTube, like these juries for the number. So. Yeah, I don't know if it's taking minutes. Redoing You can't.
Did you go downstairs?
Yeah, you just stomped out. You just stomped out.
Why?
He doesn't know if it's live streaming or not.
I'm having them pause it right now.
You're right.
He stomped out and he got upset.
Right.
Paul Evans got upset. He didn't know if it was being live streamed or not.
You went downstairs to confer with his son.
Okay. You don't need to. That's what I went back to go tell him. To probably.
Yeah, I'm trying to see.
Yeah, I said you can see the table on YouTube. Just a couple minutes to it.
I muted the judges.
And all that information. I know they need to. I don't know what you got. Yeah. I don't think you but then you also.
you doing today, sir? Good. We're just here on a pretrial setting. This case is the allegations from August 2023. Is that right?
Yes, Judge.
Okay. All right. What's our status?
Your Honor, my client needs additional time to consider the offer on the table, and we would basically respectfully request a reset.
Yep.
To the plea docket if possible.
No problem. Let's move it to the plea docket. Sir, that does not mean that you have to plea, but if there is not some resolution to your case of whatever sort it may be, the setting after that would be a trial setting. Understood?
Yes, sir.
Just want you to know what's going on in your case. All right. You have a good day. Thank you.
Thank you, Judge.
Thank you.
May we be excused?
You may. Thank you for your work, guys.
Thank you. Thank you, Judge. Can I have them sign? This is October 15th. Let me see you. Let me see you at least a couple of times. I need to set up a time for you.
Understand we're taking a plea here today? All right. Do you want to approach?
Oh, I. Sorry.
Court calls CR 23-4752F, the state of Texas versus Jabari Franklin McGilvery. Can I please have counsel make their announcements for the record?
Allison Boost for the state.
Paul Evans for the defendant.
And are you the same Jabari Franklin McGilvery who in CR 23-4752F is charged with 2 counts of robbery?
Yes.
Can you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
And with us, we have a sign language interpreter. Can you please identify yourself for the record?
I'm Barbie Parker, and my court certification number is 16710.
Can you raise your right hand? Do you promise that the translation you will give will be true and accurate?
I do. Thank you.
Okay, Mr. McGilvery, the charges as originally indicted are second-degree felonies. State, what is the range of punishment?
It's not less than 2 years, no more than 20 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000.
Do you understand that that's the range of punishment that you face for this charge?
Yes.
I have paperwork before me that indicates you would like to enter into a plea bargain agreement.
Yes.
I'm showing you the court's written admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
Yes.
On page 4, there were a list of rights that you would be waiving if you entered into this plea bargain agreement. Did you know that you'd be waiving these rights?
Yes.
On page 5, there is a stipulation of evidence. I will use that to determine if there is sufficient or insufficient evidence to substantiate your guilt. Did you know that I would use it for that purpose?
Yes.
And is this your signature on the final page?
Yes.
Mr. McGilvery, this is an agreement between you and the state. I don't have to follow this agreement, but if I don't, I will allow you to withdraw your plea and you can proceed as if this didn't happen. Understood?
Yes.
You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial. And you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
Yes.
Understanding those rights, do you still wish to proceed with this plea agreement?
Yes.
Are you a citizen of the United States?
Yes.
If not, a plea in a case like this could have serious consequences. Counsel, I have before me the discovery compliance statement regarding the state's duty to give you evidence in accordance with Article 3914. Are you satisfied the state fulfilled that obligation?
Yes.
And do you believe that Mr. McGilvery is competent to enter into this plea today?
I do so believe.
Mr. McGilvery, the reason your attorney and I discussed the evidence is because you have the right to know what the evidence is against you in your case. Did you discuss that evidence with your attorney?
Yes.
And do you believe that your attorney has provided you with effective assistance of counsel during the course of this case?
Yes.
According to your plea bargain agreement, in exchange for your plea of guilty, the state, your plea of guilty to one count of robbery, the state will not proceed on the second count of robbery, and the state will dismiss CR 244752, CR 242669F, a burglary of a building and engaging in organized criminal activity, and will decline 2 other cases. State, what are the charges on those 2 other cases?
It's another engaging in organized criminal activity, and there's an aggravated assault attached to it as well.
They are going to decline to move forward on those 2 cases. All of that, according to your plea bargain agreement, is in exchange for 4 years in the Texas Department of Criminal Justice. You will get credit for the time that you have served. Is that your understanding of the agreement?
Yes.
Would you like to enter into that agreement now?
Yes.
To the charge of robbery on October 5th, 2023, from Juan Fuentes, how do you plead?
Guilty.
Are you pleading guilty because you are guilty and for no other reason?
Yes.
State, have you given the victim in this case notice of the planned resolution?
We have.
And have you given the other cases that affect victims notice of this resolution?
We have attempted to do so. We've been unable to make contact with the unindicted victim.
Very good. Based on your plea of guilty, based on the stipulation of evidence, I find that there is sufficient evidence to substantiate your guilt, and I find that you are guilty. Counsel, is there any legal reason we should not proceed to sentencing at this time?
No, no.
State?
No, Your Honor.
Any argument from the state?
No, Your Honor.
From defense?
No.
Having found you guilty of robbery, count 1 in CR 234752F, the court sentences you to 4 years in the Texas Department of Criminal Justice. You will get credit for the time that you have served. That's 97 days. There will be no fine. Is there anything else we need to take up?
No, Your Honor.
Mr. McGilvery, I have followed your plea bargain agreement. Because I have followed your agreement, you do not have a right of appeal, and I'm signing the trial court certification. That will become part of your file. I must also let you know that because this is a felony, you are ineligible to possess a firearm or ammunition. Do you understand what that means?
Yes.
That written admonishment will also be added to your file. Counsel, anything else?
Nothing from the state.
No.
Thank you, sir. Good luck to you.
I just need a thumbprint real quick. It's right thumb. Straight up, straight down in the box. Thank you.
Thank you to the translators for being here many times on this case. We appreciate y'all. Thank you, Mr. Evans, Mr. McCray. Thank you, State.
Thank you, Judge. I don't think we have anything until next Monday, right? Okay.
Thank you, ma'am.
Hi, guys. I hope you feel better.
Thank you.